So welcome everybody to our next Ask the Expert session. I'm delighted as always to welcome back Nick Wilson, who is our go-to legal partner from Andrew Jones Solicitors. So welcome, Nick.
Morning, Sarah. How are you doing?
Very well, thank you. Very well. So I've asked Nick to join us this morning just to talk about the impending change from furlough ending at the end of this month and the new job support scheme coming into play from the 1st of November. Now, I do understand that there is lots of queries around what that scheme actually is, the mechanics of how it's going to work, claims. What I will say is we're not going to cover the intricate details on this session today, but for all our customers, if you keep an eye out, there will be another video that's more a tutorial coming that will talk you through exactly what you need to do with that new scheme. What we are going to focus on today are some of the elements that may potentially have some pitfalls, and Nick, as our legal expert, is going to guide you all through how to really navigate through some of the challenges that the new scheme might have for you. So as a start, Nick, do you want to just give us a bit of an introduction to obviously you and what you do at Andrew Jackson's, and maybe just give us an overview of your first impressions of the job support scheme?
Yes, Sarah. I'm a qualified solicitor. I've been practicing employment law for 20 years. I'm a partner at Andrew Jackson. We help a wide range of businesses with their employment law issues, typically dealing with employment tribunal claims, redundancy situations, restructuring, insolvency, TUPE situations, a wide range of issues across my desk. Most recently, of course, the introduction of the job support scheme is something that clients have been contacting us about. My initial view is that there is going to be a huge take-up on the scheme, because I think lots of businesses don't really understand what the scheme involves. They may not have done the planning involved to work out whether or not they can bring staff back on a third of their hours and then cover the additional and then apply to the government for grants as well. So it'd be interesting to see how this pans out. And of course, it's not actually that long before the scheme gets introduced. So I imagine there'll be some frenetic activity in the lead up to the 1st of November.
Yeah, absolutely. I think, we've all been commenting that there's been a real lack of detail around the scheme, to be fair. And so it's very difficult to help businesses be prepared for exactly what they can use it for. And I think, like you, we've seen first impressions are not a huge take up. And as we were chatting before our call today, I think the businesses that really are primed for needing support, those that are in the hospitality events kind of industries, probably find this not enough support for them. So I think there will be challenges that are very industry specific. So I wanted to kind of just fire in, first of all, with a question, because we have lots of clients we work with that may well have temporary layoff or short-time working clauses within a contract already. Clearly, the job support scheme is almost a version of a short-time working agreement, but I wondered if you, from a legal perspective, could just explain the difference in what might be a standard clause in a contract currently and the new scheme.
Well, in a contract of employment, you usually find a clause which allows the employer to lay off the employee without pay, or allows them to impose short-time working with a resultant reduction in salary. So this is obviously a good opportunity for the employer to look at their contracts and see if it does contain such a clause, if they've not already done so. I imagine most employers would already have done that, given what's been going on the last few months. So they may find that if they want to make use of that clause, it does fit their requirements at this time. If they have a reduced requirement for work, then they should be able to place employees on short-time working in accordance with the contract of employment. Where the job support scheme comes in is that actually it doesn't provide the employer with a right to put an employee on short-time work in order to require them to work a particular percentage of their hours. What it does is it allows the employer to claim payment for those hours. So it's still important for an employer to have a contractual right to reduce hours, and then obviously make use of the job support scheme in terms of the government's contribution. The real issue, though, is that if there is no contractual right to do this, then obviously the employer will have to consult with the employees about putting measures in place, and then any agreement that's reached will need to be confirmed in writing. That's a prerequisite of the scheme, really.
Yeah, absolutely. And we'll touch on that in a moment about the agreements themselves. So with short-time working in a contract as it is, then obviously that does give the employee the ability to request redundancy if that arrangement goes on for a period of time. So, do you foresee that would provide different challenges, or whether an employee might actually find the job support scheme better for a longer term solution?
I think those employers that have already thought about this will have already got in front of their employees and hopefully reached some agreement, and they appreciate how the scheme will support them. I don't know what you say, but what I'm finding is that a lot of employees are loath to leave a job that they already have, even though there might be a reduction in pay or hours, because it appears there's not a lot out there.
Yeah.
So they're going to try and stay in a job even if there's a reduction in pay, and even if there's no end in sight to that. They're going to find it easier to have some form of income. That all being said, I have come across a few cases recently where people have taken redundancy from clients and then walked into a new job fairly quickly. So that suggests that there might be signs of buoyancy in particular parts of the employment market. But I think ultimately the general feeling I'm getting is that employees are just happy to have a job at this moment in time. So actually, if an employer does propose that they use the job support scheme, then I sense that's actually going to be quite welcome to them.
Yeah, absolutely. So you've already alluded to the fact the new scheme does have the requirement that employers obviously must have the contractual right to be able to make a reduction in hours. So as we very much saw with the introduction of furlough scheme, and new agreements would have to be issued to employees to get their consent, in effect to allow the employer to claim under the scheme, the same will apply with the job support scheme. So, if we're faced with a situation where an employee refuses to sign any kind of consent to that reduction, like you say, assuming they don't have those rights in the contracts currently, where might that leave an employer, Nick?
Well, if there's no contractual right to reduce hours or to lay off, then the employer is bound by the terms of the contract of employment. So they will have to continue to employ the employee on those hours and give them the rate of pay that's been contractually agreed. So obviously that's not going to be ideal. If the individual refuses any variation to that, then I see a situation where that employee is at risk of redundancy. When the furlough scheme first came out, I remember that the government made some noises about the individuals didn't accept the changes to hours of work or the reduction in pay, then they were at risk of being made redundant. Now, whilst that has no legal force, of course, it is quite clearly an issue that could arise for employees. If they don't accept the changes, then presumably the employer will have some financial implications there, and they may have to go down the route of redundancy. Just on that point, Sarah, the one thing that struck me was, and you might remember, is that when the furlough scheme first came out, there was some talk about that if an employer didn't give consideration to placing an employee on furlough, it may render any subsequent dismissal for redundancy unfair if they just went straight to the redundancy instead of putting them on furlough. I see the same issue here, actually, that if an employer doesn't give consideration to the job support scheme and whether it's appropriate in particular cases, then it may well render any dismissal unfair. Who knows what a tribunal will think of that? I haven't come across any cases yet where tribunals have had to wrestle with the issue of whether or not an employer should have placed an employee on furlough, but it's always a possibility. So I think employers should bear that in mind.
Yeah, absolutely. And if an employer is faced with a refusal to sign and they decide to just impose those reductions anyway, what pitfalls might they be opening themselves up to by forcing that kind of reduction in hours?
Well, immediately there will be a breach of contracts. It's unilaterally imposed. It gives the employee several causes of action. The worst case scenario is that they could resign and claim that they've been constructively dismissed because the employer has fundamentally breached their contract of employment. They could claim an unlawful deduction from wages because they're entitled under the contract to a particular rate of pay. If the employer doesn't pay that and the employee is willing and able to do the hours, then that seems to me to be an unlawful deduction from wages. So many pitfalls. The only thing I would say is that if if an employee does resign and claim constructive dismissal, it's still for the employer to demonstrate the reason for dismissal, and they acted reasonably in treating that as the reason for dismissal. So the employer may well be able to rely upon current financial circumstances as the business reason behind the imposition of the change.
Yeah.
But employment tribunals are going to want to see that the employer has consulted with staff about this as part of the reasonable approach. So it's not something that an employer could just do. They really have to inform affected employees of the reasons for all of this, why it's so important.
Yeah, absolutely. And I think, some of the feedback we've had, and this has, more been through, like you say, hospitality events kind of businesses where, their business is impacted on an ongoing basis, but not necessarily closing. So they're not in the new restrictions where there is this increased allowance, if their business is forced to close due to tier 3 restrictions. What option realistically would a business have if they simply can't afford to pay the third top-up payment of the unworked hours under the job support scheme?
I think they're heading down the road of redundancies, really, aren't they? They just don't have the cash unless they can somehow borrow it from somewhere, arrange finance from the bank or another lender, which I think most businesses will be wanting to avoid at the moment. They won't want to take on any more of a financial burden. They're left with a situation where they will have to consider redundancies. The job support scheme just simply doesn't work for them, which is unfortunate because the whole idea behind it was to support viable jobs. And it seems to me that the measure of what's viable must take place over a period of time, not simply what happens as of the 1st of November. I think those employers will struggle. If they don't have the cash to pay redundancy payments, they can obviously make applications to the redundancy payments service for payments to cover that. But again, the employer, even if they get assistance that way, they still have to pay the money back at some time in the future. It's not a complete answer to their problems.
Yeah. Absolutely. And if they are faced, and I agree with you, the whole point of this scheme is to try and protect viable jobs. And maybe that is the key in that sentence is, there is the need that the job is still viable. They're not just hanging on to employees for the sake of trying to keep a job open when clearly the work is not there over a longer period of time. So maybe some harsh decisions have got to be made, and this might force that if a business hasn't already done so. Like you say, if they are forced to make redundancies and they find they're unable to pay the statutory redundancy payments, then clearly, even if they're still trading, there is some support through the redundancy payment service, which quite rightly, as you've said, isn't a grant. It is, almost a loan. They have to repay that. What about in terms of negotiating with employees, Nick? If they've got a redundancy situation, rather than using the redundancy payment service, could they negotiate to pay redundancy in instalments directly with the employee?
They certainly could, yes. There's nothing to stop the employer attempting that. And obviously part of that process is really impressing upon the employee why this is needed, because ultimately, if the cash isn't there to be paid within a couple of weeks of when the employee leaves, then there's no point really in the employee then demanding the money, is there? It's just not going to be there when they want paying. But if there's an agreement for them to be paid further down the line, such as by way of instalments, as you say, then I don't see any reason why that can't be achieved. The only downside, I suppose, is from an employee's perspective, they're going to want some guarantee they're going to get the money.
Yes.
And that's the tricky question here, isn't it? Is the employer going to be able to strike a deal where they say, you can have your redundancy pay, but it's going to be over 3 or 4 months? Possible, and let's hope that can be achieved. But I'm not sure it's that straightforward, unfortunately.
No, I think if you flipped, I suppose, from the employee's point of view, if your employer is struggling financially, I guess the question will be, is that business going to be there in 3 or 4 months' time to even pay those instalments? And if it isn't, it leaves you very little option to try and recoup that money, doesn't it?
That's it, yeah.
That's great. In terms of, and I think, there's some of the key issues that we wanted to cover off. I think you're quite right in saying, Nick, a lot of businesses throughout the last few months, whilst the furlough scheme has been there, have probably used the time as an opportunity to really review their business, look at the structure within it, you know, how efficient they're being. And they've now really already approached maybe some of those firmer decisions as to whether redundancies have got to be made. And if so, I've put that in play. You know, it is worth bearing in mind, you know, the outline of this new scheme for everybody watching is that whilst you are in a claim period under the job support scheme, unlike furlough, you cannot place someone at notice of redundancy. So you in effect have got to have stopped claiming before any notice period commences, which is a big change, and financially I'm sure will make a difference to some of those employers. So planning ahead, which, you know, Nick and I have said this from day one, you know, looking ahead and making those plans sooner rather than later, and having, you know, last minute knee-jerk reaction to the changes is absolutely critical at the minute to make sure that you are, you know, utilising the support that is there. Nick, are there any other comments on the scheme in general from your perspective you want to add today that you think might be of help or of use to any businesses watching us?
I don't know if there's any help, but I think we've discussed, haven't we, that the absence of firm guidance, really. The scheme comes in very, very soon. We're still awaiting the more guidance from the government or the Treasury as to how this is going to operate. Businesses need to know what's happening. We think there's been a bit of a low take-up so far. Is that because there simply isn't the information out there? Quite possibly. Or it might simply be that employers are just haven't got round to thinking about it. And I imagine a lot of businesses are taking each day as it comes, really. And that's the difficulty for them. So I think it's all the more important for them, isn't it, to try and seek advice, really, and get that planning in place, as you say, because ultimately they don't want things to come to a head very quickly, because then when you have to start making things like redundancy consultations, you then run the risk, don't you, that if that's something you need to do to save the business, to get rid of staff, well, the shorter the redundancy consultation, the more it points to an unfair dismissal. If you've got collective redundancies, then there's timescales that need to be observed. You know, this is why it's really, really important that employers plan properly, observe the proper timescales, and therefore reduce the risks of any unfair dismissal claims.
Yeah, absolutely. And I would entirely agree. I think the frustration with the companies we support is around the lack of clarity. And, you know, we've got an outline of the scheme, and it is just that at this moment in time. So things like the practicalities of getting agreements sorted out, you know, the difficulty is we act now and those agreements might not actually cover the final draft of what the scheme looks like. And I think there is some uncertainty because, you know, if you refer to the Treasury fact sheet that has been issued and is available for anyone to download, you know, what it also makes clear is that this scheme is going to be reviewed after 3 months. So although they're talking about it being a 6-month support package, realistically, the support it's offering, you know, in terms of people have to work only a minimum of a third of their hours, may change 3 months in. So I think that leaves a little bit of scepticism as to how effective this is really going to be to plug that gap for those businesses that need it the most at the minute.
I think the other issue is that the government's contribution is capped as well, isn't it? £600.92, I think, and that's a month. So, you know, what happens in situations where the employer is required to pay more than what they might be expected to do simply because the government's cap doesn't cover enough. It's really difficult, and it seems to me there's a huge difference between what's been provided to employers who can keep open viable jobs when you compare it to businesses that are forced to close because they're placed in tier 3 restrictions, for example, because the level of support there appears to me to be much greater. You know, it's almost in line, isn't it, with the current furlough scheme in terms of the level of the government's contribution. So it's difficult.
Absolutely.
Yeah.
So no doubt a can of worms to be opened. And as I say, hopefully what today's session has given you is just a little bit of an insight of some of the potential, as I say, pitfalls legally that might just need to be considered as you're considering your options moving towards the job support scheme and moving away from furlough. For our Ask the Expert sessions, we know that times are tough for lots of businesses out there, and you know we've had a range of experts providing some great advice for businesses just to help them really trade through to build stronger teams, which is what we're all about. Our next session, we are going to be joined by a business rescue expert, Tim Carvler. He works with lots of businesses and is trying to make the most of the new legislation that's come out this year to hopefully help businesses survive the pandemic rather than have to close as a result. So he's going to share with us some great tips and advice on some options if you are finding yourself where you are perhaps struggling and need a little bit of guidance and support. So do join us next time for that. In the meantime, Nick, as always, thank you very much for your time and wisdom. We will no doubt see you again when the next issue raises its head that we need your advice on.
Thank you, sir. Thank you.
Perfect. But for now, thank you all for watching, and we will see you next time.